He wouldn't be writing that and saying that unless his clients had come forward and said, we're not happy. So I don't think COSATU is happy. I think some of the independent unions are happy. I've spoken to quite a lot of the independent unions, independent catering, hotel and allied workers union are very happy. They said, right, that's the ruling, that's what we accept, let's go forward and let's have some certainty. So the smaller unions who want to get on with their lives are happy. I don't think COSATU as an umbrella body is happy. So my short answer again to you is, no, this is not final. This is law in the making. We're living through history now in South Africa. Wrong time to be living through history. It's an old Chinese curse, may you live in interesting times. As a curse, I think it is a curse. I think that this is not a court of final countdown. It's still got to go to the Labour Appeal Court, and even from the Labour Appeal Court, it could go to the Supreme Court of Appeal. It could even go to the Constitutional Court, because there is a constitutional issue here, because there's a right to employment in South Africa. So we've still got those tiers that we need to climb. I'm not sure if we will climb it. I don't know. My strong feeling as a lawyer is watch this space.
So, setting aside the previous ruling by the CCMA arbitrator, the client organisation is the sole employer of employees after 3 months. The Labour Court's judgment was that the deeming should be interpreted as augmentation rather than a substitution, and that the client organisation is a concurrent employer rather than the sole employer.
Yeah.
So, Michael, in this context, what does augmentation mean? And then we'll go on to ask what does a concurrent employer mean?
Concurrent.
And how does it translate into a real IR context?
Yeah. I think the judgment was good because they then left the door slightly ajar. What they were saying is the TES is the employer. Excuse me. Being the employer, they're saying then there is still some value in the triangular arrangement that exists in our law. And the value is that if the TES can't satisfy the necessities in terms of the labour legislation, the 11 pieces of labour legislation, let's say the TES hasn't deducted UIF, for instance. The court has now left it open and said that the employee of the TES can look to the clients to augment what the TES can't do, or hasn't done, or can't afford, or has disappeared, or whatever the case might be. And that's what's augmenting the rights of the employee, which is what the law is trying to do. The law is trying to protect the employee from the ogre of the business person. And so they use the word augmenting, the judge used the word augmenting, and the reality is that's what the law actually wanted to do. The law wanted to create more safety nets for the employee. And of course the temporary employment services, the good ones, the ones who have put into place all their services, they have backing, they have money, they have a relationship with their clients, those good temporary employment services are only too happy to say, yes, there must be augmented, there must be the safety nets. We want to protect our employees. And they haven't balked at that problem. So using the word augment is a good one. And in fact, I think that truly describes what the legislature wanted to do. They wanted to augment the safety nets of that employee. Now, we then go on to say, and the judge said, that there is some sort of concurrent liability from both the temporary employment service on the one hand, who is the employer, and the client who receives the services of that employee of the employer. And they're saying that that concurrent liability means that the employee or the union can look to either one. And the lawyers use the phrase, the one paying, the other to be absolved. So that's what this is all about. There is a concurrent liability. And that concurrent liability, quite frankly, is a good one. So to answer your question, It just gives the employee rights from both.
So, in terms of what that means, because I think this is where a lot of business is confused, is, well, if the CCMA or the employee can come after me, why do I use a TES? What's the point? What value does it offer? So, does the employee or the union or whoever it is get to pick who they go after, or does it depend? So, for example, if someone is a temporary employee with a TES agency and they're working in a big, say, corporate brand, because that's the client of the TES, and something goes wrong in terms of, I don't know, like you mentioned, benefits aren't paid or pay isn't met or unfair dismissal happens, is the employer exposed as a first port of call? Is it a choice that, because in all likelihood, someone may want to go after what they see as the bigger name? Or is it only if the TES agency can't meet its obligation against the finding, and who decides that?
Yeah, I tell you what this court ruling is saying, and I think it's clear, and let's not get ourselves confused. The court ruling is saying that the TES, the Temporary Employment Service, the labour broker, is the employer. And they put a full stop next to that. They're also saying that if that TES can't meet the expectations of the law, then the client has to step in. Now, when you sue or when you take someone to the CCMA, it would be wise of every employee in every trade union to cite the client alternatively. In other words, the first respondent will be my employer. The second respondent will be the client. Now, yes, that will put the fear of daylights into the client, because they're saying, well, we're going to the CCMA now anyway, because we're the second respondent. And it's wise to put them as the second respondent for a whole lot of reasons, but the one being is that if the TES doesn't satisfy whatever the ruling is, they become liable. So they'd like to be there and be informed of what's going on anyway. What the TESs are saying, the secure, solid TESs, the labour brokers that have responsibility, are saying, we will indemnify. We know that you're going to be the second respondent. And you and I have discussed this in the past, and we know that what's happening is the TES is saying to the client, here's an indemnity. We will stand in and satisfy every single ruling. Please give us that opportunity to satisfy it. We don't want to hide anything, so we'd like you to be fully aware, and we're happy that you get nominated as the second respondent, because we want you to be fully aware of what happens in our business. So if the employee is saying you didn't pay UIF, I think the client ought to know. And that's why I've always said, and I think both of us have said, that the client needs to have full insight into the books and the practices of the TES. Long gone are the days where you have that bucky brigade saying it's none of your business as to what I'm paying for my employee. That doesn't exist anymore. So the employee himself or herself will in fact nominate first the employer, first respondent is the TES, and will nominate the second respondent as being the people where I work. And that's what the law is now asking you to do.
So acting Judge Martin Brassey found the following, amongst others: the TES remains the employer of its employees beyond the 3 months. Is there any update on this? Anything employers should be aware of?
Let me first tell you that Judge Brassey, acting Judge Brassey, is probably one of the country's foremost labour lawyers. He's been practicing labour law for many, many years, I think for 35 years. Judge Brassey, acting Judge Brassey, was one of the authors of the current Labour Relations Act. And Judge Brassey has very carefully had a look at the wording of the current amendment, and hence his judgment. I think the judgment is correct. I think we're going to see some amendments to that judgment, maybe on appeal or on review. We're going to see some commentary on it, and I think Judge Brassey has left it slightly open for further interpretation. But as the law currently stands, and I think for at least the next 12 months, Judge Brassey's judgment is the law.
And if it was changed after 12 months, any case decided within that period can't be retroactively applied?
No. So this is the law. And Judge Brassey, and in fact, in 2 weekends' time, I'm going to be spending the weekend discussing labour law with him. We're getting a group of people together to discuss the labour law. Obviously, foremost on my mind is this judgment. He's worrying about another judgment, and that's why he's getting some labour lawyers together to look into another issue, which we'll have a debate on some other time. But foremost on my mind at the moment, because my clients are all clamouring to find out, is this the law? It is the law. There's no update on it, that's the law, and we can be rest assured that that's going to be the law for the next 12 months, and we can also be rest assured that if any changes to the law happen, it's not going to be retrospective.
Okay. The extension of the deemed provision is sufficient only as far as extra protection to TES employees in terms of the Labour Relations Act. What does this mean in practice?
What it means in practice is that the TES stands in as the employer, that it's business as usual, that we can go back to where we were before this CCMA ruling. We can have a look at it on the basis of the TES is the employer, the TES will place that employee with the client, and the TES has to hire, fire, discipline, etc.
Okay. Nothing in the law states that TES is to be substituted by the client after the 3-month period. From what you've seen, have employers been behaving like it did?
Yes, there was, obviously after that CCMA ruling, there was that uncertainty, and the clients panicked. The clients said, well, if we're the employer now, what are you doing there, and why are we paying you, and what's the issue? And there was that running, the scurrying around. It was a situation of almost chaos.
And before the CCMA judgment, but after the law came in, we were seeing similar things where everyone was being made permanent or...
Correct. But, before that judgment from the CCMA, the clients weren't sure, because some experts were saying A, some were saying B, clients weren't sure. I think this ruling now from the Labour Court gives a good lid to this problem, and it's not bubbling over at the moment. Yes, there is some pressure building, but it's not bubbling over, and we can be rest assured that the law is certain now. For a time being, but it's certain. It's certain that the TES, the Temporary Employment Service, is the employer. After the 3 months, still remains the employer.
Okay. The principle of triangular employment relationship, as per the original section 198. What does a triangular employment relationship mean here, and what difference does this make in practice, if any?
Yes, the triangular, and I think most of the TESs who were responsible looked at it as a triangle. They're saying, we as the TES at the pinnacle of the triangle, we then employ an employee. We then place that employee with a client, and the client looks to us to hire, fire, and to take the action, the disciplinary action. So it creates that triangular relationship. What Judge Brassey is saying in the Labour Court, he's saying that triangular relationship is only necessary in our law when the TES doesn't satisfy the law. If something goes wrong and the TES hasn't satisfied the law, then we can all look to the client and say, this TES, he's gone off to Honolulu, he's disappeared with the salary, he hasn't paid the employee, now let's look to the client. And that's what he's saying. And he's saying, yes, the triangular relationship is intact, but it is the lines between the employment are very strong between the TES and the employee, not the other way around.
Okay.